not following the rules, and that's the very first step. Jurisdiction. Does the court have jurisdiction? And if it does not, then it has no lawful authority to be a court. It has no power to speak the law. Anything it does, any decisions it makes are void without force or effect on the parties involved in the dispute. Article 3 of the United States Constitution says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. Now, there's two different law jurisdictions that exist. We know common law and admiralty. We're not talking about that, so let's get past that for a moment here. I don't care which one we operate in. Admiralty is fine by me. It's even easier than common law because admiralty is contract law. I can win in contract law. Show me where in the four corners of this contract it says that you can do something or forbear from doing something, and if it does not, I win. So I'm fine with contract law, but that's not what I'm talking about. What I'm talking about is jurisdiction of the United States Supreme Court. Under Article 3, it identifies two instances in which two different types of jurisdiction the court has. One is original jurisdiction, the other is appellate jurisdiction. Now, original jurisdiction means that they are the court to act first, before any other courts. No other courts in the country can act before the court that has original jurisdiction. Now, we believe that the lowest court in the country, being the district court or whatever, the municipal court, whatever you might have within your state or your particular area, whatever the lowest court is typically the court of original jurisdiction. You break the law, you go to the lowest court. But not if a state is named a party. If a state is a party to that cause, it does not have jurisdiction. The United States Supreme Court has jurisdiction. That's why I say that we need to first look at what it is that we're looking at. If we're looking at an institution that has been committing crimes for 245 years, then obviously criminals have been leading us toward criminality, right? And if they're leading us toward criminality, you need to decide, do I want to be a criminal? If I do, then I'm going to follow them. I'm going to keep on following them. I'm going to do what they say. But if I don't want to be a criminal, then let's try the other direction. So instead of going to the lowest court, let's follow the law and let's go to the highest court. Instead of appealing something, let's go ahead and say, no, there's nothing to appeal because the judgment's void. Instead of arguing case law, let's argue constitutional law. Instead of following an attorney, let's follow an advocate, right? Let's go the direction of freedom. Let's go the direction of the lawfulness, because the only law that sets free, the only law that we are bound to follow is the Constitution of the United States. And it's not that difficult. It's only 4 pages. Don't worry about the 800 million or 800,000 pages of law and statutes and everything else. Don't worry about that. Let's follow that law, the one law, and let's let the law that enslaves and imprisons, let's let that go ahead and go with the criminals. Let's let the criminals continue to follow that. Let's go the other way. So what I'm saying and what I'm proposing is that we go the opposite direction from now on. Yes. Don't listen to what they're telling you to do, because an attorney goes through what's known as adjudicative law. They learn about the adjudication of process. They learn about statutes and ordinances, customs, judge-made rulings. They learn about all these laws that remove freedom, because that's what they're in the business of. They create criminals. And we know from the 13th Amendment, this slave is a prisoner and a prisoner is a slave. They're synonymous with one. They mean the same thing. So if you're a prisoner, if you're a criminal, then you're now a slave, according to their own laws. So